Let's see the facts of the case.
H and W had 5 children, and S was their only son. Their first flat was in W's sole name. When it came to buying a second family flat, W was not eligible for a home ownership scheme, so the application was made in H and S names. There was a common intention among the family that the property would only pass to S as the only male descendant when W and H had passed away, and that H and W contributed to the mortgage repayments. Afterwards, S became the sole legal owner in 2012 when H passed away. W continued to reside there, and upon H's passing, Primecredit then sought a charging order for the sale of the property against S regarding a loan unpaid by S. At first instance, W's claim that she was a beneficial owner of the property was rejected, and the judge held that W's evidence on common intention was libelous. Therefore, W appealed.
He is the ruler of the case.
The modern approach to constructive trust was to assess the common intention of the parties by a comprehensive approach regarding the contest. In the Chinese setting, it is common that parents would acquire a property in the name of their children and yet retain control and beneficial ownership of the property during their lifetime. Especially for the older generation, explicit discussions on property rights within family were not common, so the court should pay more attention to circumstantial matter. More importantly, W has directly contributed to the repayment of mortgage. Therefore, majority held that the circumstances were sufficient to infer the creation of a common intention constructive trust. On the other hand, minority agreed that W had a beneficial interest but relying on presumed resulting trust rather than a common intention constructive trust. There is no error of law that judge at first instance was entitled to take the view that the evidence was so nebulous and fake that, on the balance of probabilities, there was no common intention.
There are two differences between constructive trust and resulting trust. First of all, they arise in different ways, and secondly, they give rise to different things. For the first difference, resulting trust does not rely on the intention of the parties. Constructive trust arises only when there is a conduct inferring an agreement reached between parties on how the property is to be held beneficially. The second difference is that resulting trust gives rise to a presumed common intention. Note that for constructive trust, common intention must be proven and not presumed. So which doctrine should we consider first? For application of the doctrines, it is not necessary to consider resulting trust if the common intention constructive trust has well been established. If beneficial interest could not be deduced by evidence, resulting trust should be considered. For both doctrines, the court should consider the inherent probabilities regarding circumstantial matters at the time of acquiring the property. Also, we should not regard resulting trust as a weak assumption which can be easily rebutted. It can still be relied upon to establish beneficial interest. Presumption of advancement was not used since the presumption did not apply to a mother and dependent child in 1985.